remarkably like Graeme. So Graeme has volunteered to go through a summary of Stephen's paper for us today, and we really appreciate your doing that, just as we understand Stephen's not being able to be here. So I'll now call on you to give us a summary of his presentation.
Yeah, thanks. I was really disappointed that Stephen did have to go home, partly because it's his mother-in-law is very close to death, and it's a very sad time for him. But I said earlier that it's great to have friends coming to these meetings, and Stephen, besides being a friend, is just a towering scholar in the migration area, having started up the Oxford Migration Centre, which is now one of the major migration research centres in the world. His paper, Rethinking Australian Migration, and you'll have to forgive me if I look down at things here because I only was introduced to this 5 minutes before we came into the room. I do know a bit about Stephen's work, so it's not quite a totally new thing to me. But the basic idea of his paper is that the Australian migration model, which is pretty much based on traditional settlement migration, even though we've had these changes since the mid-90s, a lot of our thinking about migration is really based on citizenship, multiculturalism, and a permanent settlement model. And one of the most interesting parts of his presentation I found was where he puts forward what he felt were 7 traditional long-standing beliefs which governed our thinking about migration, and suggested there were emerging trends which were challenging those. And I'll just run briefly through those. The first of these long-standing beliefs is that you can totally control your borders. And globally, we're seeing that there are many countries now which have very porous borders. My own feeling is that Australia does control its borders very, very well and is able to. It has, just by its geography, and Japan is very much the same way. There is very little clandestine undocumented migration. Other kinds of undocumented migration are significant. The Australian government decides who comes. That's one of the traditional beliefs on which our migration is based. What he's suggesting is that it's markets, families and individuals who decide. Again, I think in the Australian context, the government is still able to exercise an enormous amount of control over who comes and goes because of this island nature of the country. The third assumption is that everybody wants to come to Australia, and there are a massive availability of skills out there which all we have to do is to put up the open sign and we'll get flooded with applications. Now, the reality is that is changing. When I first started studying migration, it was Australia, the United States, Canada, and to a lesser extent New Zealand, and that was it in terms of countries that had planned migration, recruitment type policies. Now, as I said, there's about a dozen Asian countries, let alone European countries and so on, that have really often quite innovative skilled migration policies. Recently I've been looking at Korea, where they have enormous trouble in attracting people because of the language issues and so on. But they've introduced a gold card for people with PhDs, which allows them very free access to and from Korea if they have a work task in the country. But we're looking now at what's really a war for talent. As countries realise that they can not only build up human capital through their education and training systems, but through migration, that's really becoming enormously competitive. And Australia's got a lot of comparative advantage to compete in that arena through lifestyle and security and freedoms and so on. But it should never ever be complacent that it's always going to be first choice for people. And in fact, there's a lot of evidence that it's not. A predominance of settler migration, and what he's suggesting is that now it's a much more complex, diverse system, including a whole range of temporary and circular and return types of migration, as well as permanent migration. The fifth assumption is that it's one way, that people come and stay. And I think some of the work that's been done on Italian migration to Australia, to me, is very interesting in this respect, because the initial waves of Italians in the 50s and 60s were in a situation where their visits home would be once every 10 years, if possible, and keeping in touch by letters. Now, and particularly the older generation of Italians, many actually live in both countries and circulate between the two. And Skyping and a range of other methods are used in order to maintain those linkages. It's a totally different global situation, so that circulation and belonging to more than one country now is much more feasible than it ever has been in the past, and needs to be recognised. Most entrants want to stay and become citizens. That's a really interesting assumption, because very often that's not the case, that people don't necessarily want to become citizens of Australia, and that they see their stay here as being a temporary stay. And having systems which deal with that in a effective way, I think, is very, very important. And the final one relates to national identity, and this whole idea that people have to identify with a single country. And this is being challenged increasingly with people having multiple transnational identities. And Stephen mostly just raises these issues in relation to Australia, and really his paper is saying, how do we deal with these changes? What do we need to do in terms of, for example, our policy on multiculturalism? Really the original formulation of multiculturalism, going back to the Galbally report, was really for a very different time in terms of the migration which actually occurred. And he suggests that we really do need, we really now are defining multiculturalism. Originally we defined it in terms of citizenship, rights and obligations, but now the emphasis has shifted to cultural belonging, harmony and social cohesion. And having a multicultural policy which is evolving and taking these things into account while retaining the basic equity and rights elements is very, very significant. He talks a lot about what are the implications of temporary migration? What does it mean in terms of personal identity and belonging? And he suggests that it requires new solutions in terms of settlement policies. I guess his basic conclusion is that if Australia is to continue to get substantial benefits from migration, as it has in the past, there's a need to focus on two emerging issues. The first, how do we maintain our comparative advantage as an attractive destination for migrants? And that is particularly significant, I guess, in the whole area of skilled migration. So on the side of migration, that's what he suggests is the number one question. On the side of settlement, he says, how can our settlement and multicultural policies be remoulded in order to respond to temporary migration rather than respond to permanent movement? His conclusions, he assesses that, in general, the Australian model of migration and multiculturalism have been highly successful, that there is a real need to rethink migration because of these changes. But one thing stays the same, and that is that we must maintain principles of equity and inclusion in whatever new forms that we come up with. Now, I'm sure that's a very inadequate summary of the paper because it was done very much on the run, but I think we'll leave it there. But I'd certainly urge each of you to look at the paper. So I think there's time for Peter.
Well, thank you very much, Graeme, for doing that, and I know Stephen would be very appreciative of your efforts there. I don't know if we want to, it's a bit difficult to ask questions of Graeme about the paper, but people may want to make any comments on the issues raised in that context. If not, what I think we're moving on to now is, Peter, you've very kindly offered the opportunity to make some comments, Peter McDonald, on the 457 review. So would you please welcome Peter McDonald, who will also be talking after morning tea as well.
Well, as you've heard, the government created a panel to review the integrity of the subclass 457 visa program to Australia. It's a report to the government. It's not a report of the government. It's an independent report. And it was chaired by John Azarias, other members besides myself, Jenny Lambert and Katie Mallion. That's the report. It's now available on the website of the Department of Immigration. The report arose because last year there was controversy surrounding 457s, and you can take your own take on why that was the case. But the controversy was around two main issues. One was compliance, that is that maybe, as was mentioned earlier, perhaps 457s were being paid much less than they were supposed to be paid. Maybe there were other kinds of activities going on, and one that's mentioned is sometimes there are sweetheart deals between the employer. The desired outcome is permanent residence in Australia, but there is a sweetheart deal between the employer and the employee, the 457, to enable that to happen. There are compliance issues of a wide range, but they are some of the main reasons that were to be investigated. The other main controversial issue is the one of appropriateness, or that, to put it crudely, 457s are taking the jobs of unemployed Australians. So they were the two main issues that led to changes in the system at literally 5 minutes to midnight of what was then the Rudd government. Before the election, legislation was introduced to make various changes to the 457 system. In the more than 12 months now since those changes were made, the number of 457s has dropped very substantially. And that's another issue, but I might talk about that one later on. But let me deal with those two issues and how we've addressed them in the review. The compliance issues, there are issues of compliance. There was a lot of debate last year about the level of corruption, as it were, and the minister at the time said there were 10,000 people corrupting the system. And there was a lot of debate, and of course there was no evidence for that number. He was not able to present evidence for that number. But we did a fairly intensive investigation. All we could do was make use of the department's own data on compliance. The vast majority of non-compliance is fairly low-level non-compliance, that is people who don't understand the system and they're not doing something properly. And once they're told by the department that they're not doing it properly, then they fix that up. And so we've said that they should be educated so that from the beginning, and the 457s themselves should be educated to make sure that these smaller mistakes are not being made from the beginning. The large compliance cases, that is where they are sanctioned or the visa is terminated, constitute probably about 1 to 2% of all cases. It's around about that area. And they are concentrated in the areas that you might expect in the low salary end of the 457. Remember, a lot of 457s are very highly skilled and very highly paid. You know, the CEO of BHP, etc., they're on 457s. But there is, at the other end, near the limit, the salary limit, is where the problems occur. They tend to occur in certain occupations as well, of a relatively lower skill. It rarely occurs for anybody who is a professional, a professional. There were also some occupation categories that were problematic, that were essentially being used. These were largely manager, not elsewhere classified type occupations that were being used by people wrongly. And the changes that were made last year moved against those kinds of occupations. And as far as the review is concerned, we supported that notion that those occupations should be scrutinised, and that was correct. But on compliance, the Fair Work Commission is now involved in the Fair Work Ombudsman is now involved in looking at the cases at 457s. It's just part of their normal work. They go to a workplace and they look at whether there's 457s there and whether that's a problem. And they are concerned with the two issues that we talked about earlier on. Are they being paid the right amount of money, and are they doing the work that they're supposed to be doing? And reports then go back to the department where the Fair Work people are concerned, where there is a concern. We've made some suggestions to smooth that process, to make it more efficient, and provide the department with more resources to actually follow up on those cases. The other major change that we suggested was that there should be a linkage to the tax office. We've said that there should be legislation passed that the 457s have to provide their tax file number to the Department of Immigration, and the Department of Immigration will then match in cooperation with the ATO, the tax office will match to make sure, of course, that this is about the amounts of money they're being paid, that they are being paid what they're supposed to be being paid. And, I think there's probably a strong likelihood that the what you might call corrupt Australian employers who are rorting a 457 system are also likely to be rorting the tax system. And so the tax office is very happy with this approach. And that was one of the things the Minister mentioned yesterday. In terms of the compliance area, pretty much everything we recommended was taken up by the Minister in his speech yesterday, and I think it looks like the government's going to move in those directions. The one problem, however, is resources, money. Costs a lot of money to take somebody to court, and that remains the problematic area. In relation to the appropriateness, are 457s taking Australian workers' jobs? What was done last year was to introduce labour market testing. There were some other measures as well. A good measure which was called the genuineness criterion. Now applications are assessed on the basis of their genuineness. That is, you look at it and you say, well, why does this small cafe need an electronics engineer? So it's about appropriateness, and that has been very effective, I think. It seems to be working quite well. So the officers look at the size of the business and what it does, and who is coming in and what they're going to be doing, and does it look right? a very simple thing, but you would think. And that's been applied very effectively, and we support that direction, which was introduced last year. Labour market testing, however, as I've said, that labour market testing was used in the 457 system in the past for a short period, just towards the beginning of this century, but was wiped out for being ineffective, was reintroduced as part of the changes last year, and it's still completely ineffective. Nothing has changed. As we understand it, there has been one case questioned in relation to labour market testing, one. So labour market testing as it's applied at the moment under the new legislation does not stop anybody coming into the country, maybe one person. And the unions in their submissions recognise that, but their approach to it is that at the moment it's roughly only about one third of applicants are labour market tested. The other occupations and salary levels are the high ones, and they're kind of exempt. And the employers, the state governments, etc. So they're exempt. But the issue was, well, okay, labour market testing is not working, can never work really. And the OECD has concluded this. You know yourselves, if you're an employer, that if you want a particular person, you can word a job so that it fits that person, and you get it through the system. So it's a totally ineffective method. Unions want to increase the severity of the labour market testing, want to spread it across all, this ACTU, want to spread it across all occupations, and to apply it in a very much more stringent way. That's their answer to the problem. And if that were to be done, then that kills off the 457 system pretty much altogether. So, because it becomes so cumbersome and so expensive, etc., that people will not want to use it. So we decided not to go in that direction, but we said that something had to be done. And at the present time, the permanent migration system, that is those that are the general skilled migration stream, has a list of occupations, which is called the SOL, S-O-L. And you can only get in the permanent program, in the general stream, if you can prove that you have that occupation. And that occupation list is changed, updated all the time by a group of labour market economists and so on in the federal government. And we thought, well, why not do that with 457s as well? That is, that you have a system, you have a list. The list may be a wider list, but it would be a wider list. But each individual occupation is assessed by a labour market group, and that you could either take it right off the list. If there are loads of Australians who are looking for jobs in that particular occupation, you take that right off the list. If there are a fair number of Australians, but maybe we still need some migrants, then you could think about capping it, capping the numbers of 457. So we're suggesting a process, an analysis-based process, which is exactly the same as what is now applied in the permanent program, be applied to the 457. And in order that both of those lists, in fact, have a broader scrutiny, that this system would be overseen by the Ministerial Advisory Council on Skilled Migration. One of the terms of reference we had was to investigate whether Australia should have a Ministerial Advisory Council on Skilled Migration. We recommended that Australia should have such a council, that it should be a tripartite exercise, so that unions or employers in particular can bring their cases to the Advisory Council. The Advisory Council then can refer them off to the the boffins who are working on whether this occupation needs to be restricted or needs to be opened up, whichever way it is. And we would hope then that you get a nice system operating. The other reason for doing it is that because a lot of Australian migration now, as I'll talk about later on, the 457 has become very much central to permanent migration. It's a pathway to permanent migration. And therefore, it's not such a bad idea to link the two systems so that the CSOL list, the 457 list, and the SOL list, the permanent list, have some coherence. So, for example, there are lots of occupations on the permanent list where the group who've investigated have said that Australia has an absolute shortage of those people, but they are labour market tested within the 457 system. It's just illogical. So it's better that they are brought together in a single system. Now, okay, the government has said on the compliance issues that I talked about before, that bringing in the tax office, etc., it looks like they're going to go ahead with all of that. But in this area I've just been talking about, that is still a blank sheet, as far as I'm aware. To maintain the present system with labour market testing is not going to do anything. As I said, nobody is knocked back by that testing system at present. It's totally ineffective, it's cumbersome, and to not put in place an advisory council and a group that are looking at that, I think leaves the problem where it was, does not solve the problem. It's very important for the integrity of the 457 system in the eyes of the Australian community that they do see that kind of scrutiny is going on. So I'm here to sell these ideas to you. We do see that as quite vital as part of the process. We looked at the system as a whole, and there are other areas that we looked at where we've suggested some major changes. Perhaps the most important one is the training benchmarks. Training benchmarks were introduced after the Deegan review in 2009, and they require a company to either prove that it is providing 1% of its payroll in training, or they have to make a cash payment to a training institution, registered training institution, of 2% of their payroll. They have that choice. And we found this to be a complete shambles, that there are lots of problems with it. One, the department didn't even know whether these amounts were being paid. Two, a lot of employers didn't know quite who to pay the money to. They know they had to pay it, but who do I give the money to? Three, educational institutions were receiving a cheque from some employer. They knew nothing about it, what it was actually for. And it's a total shambles. Four, there was allegations of corruption, or that there were kickbacks to migration agents by the shonky end of the educational institutions, not the University of Adelaide, of course, but the shonky end. And so it was a total shambles, and not effective either. The 457, it was about the notion that, okay, if we're bringing in people from overseas, we should be training Australians, in those kinds of areas. But the amount of money or the number of people is so small compared to the training costs, it can never make a chip at all in that problem. And so we said, well, okay, if there's a Ministerial Advisory Council, the Ministerial Advisory Council can point out that these are areas where there is a need for training of Australians. But as far as the training contribution is concerned, we took a somewhat radical approach and said, okay, let's turn it into a social licence, that there will be a payment per annum per 457. It's a single amount, around about $500 per person per annum, and that will be provided to the government and the government will use that money in training programs for disadvantaged Australians. Okay, so we've suggested, we're never going to fix up the problems of shortages of electronics engineers through this kind of system. But we do recognise the need to train Australians, and so let's take the social licence approach. Now that was that's a radical kind of approach, which from what was said yesterday has some appeal, I think, to the government, particularly the Minister for Industry, who suddenly gets a lot of money to spend on training disadvantaged Australians. So that department was quite interested in the idea. On the compliance, I should have mentioned earlier on also that we have recommended with the Sweetheart deal that this be made illegal, a criminal offence, and that this is the case where the employer and the worker get together. The worker wants permanent residence in Australia. The employer says, okay, I'll work for me as a 457 for 2 years, then we'll nominate you for permanent residence in Australia. But, you can pay your own salary. Or, you won't get quite as much. So it is a very corrupt practice, which has to be knocked on the head. Its legal status was a bit fuzzy, and so we've said that there should be legislation to make that illegal. And hopefully the government will also provide a little bit of money to so that if there is such a case, that people can be prosecuted. Some of the ideas in compliance, that one and the one with the tax office, we thought there was a kind of demonstration effect. That is, that if you introduce measures like that, people will be frightened off from bucking the system. So if they're tied up with the tax office, and everybody's scared of the tax office, then they're not going to be heading in that direction. Same with this, making this illegal, that you can potentially be put in jail for this kind of exercise, for the Sweetheart deal. There were other issues that you can read about which are less significant. We did suggest a more streamlined approach in the processing for the red tape, as it were, so that a lot of employers have very good records, etc., that they should be able to streamline through the system much more readily than those that are the small end and have people on much lower salary levels and so on. As for salary levels, there is something called the TISMIT, which is the kind of minimum salary, as it were, that you're allowed to pay to any 457 worker. We maintained the TISMIT. There's a lot of pressure on us, from different places to abolish it. And if this labour market assessment was in place that I was talking about, where each occupation is heavily scrutinised, and if there is a scrutiny on payment of market rates, which is there, and we've supported that, of course, maybe you actually don't need the TISMIT, because the list is never going to have labourers and so on it. It's always going to be a skilled migration list. But we maintain the TISMIT for the time being, but said it's something that could be investigated in the future. We talked a bit about fees. We think that at the same time as these legislative changes were made last year, there was an enormous increase in fees, and we think that has had a bit of a price effect and is part of the dampening factor at the moment, particularly at the lower salary end. So we suggested the government have another look at the fees, particularly for people who are getting a renewal of their visa, for example, or for secondary applicants as well, people who are coming in with the 457 visa person. Okay, well, I'll leave it at that. If you maybe you don't have time for questions, but I'm happy to take them.
Well, Peter, thank you very, very much indeed. This has been a special treat and a kind of breaking news kind of way, really, that you, as a member of the panel of a report that was issued yesterday, were able to give us such a comprehensive summary today. Are there any questions at this juncture? There's a lot to digest there, but that was really a wonderful summary, so thank you very much indeed. Oh, yes, a question back there, yes.
Hi again. G'day, Peter. My name's Mark Glasbrook. I made a couple of submissions to the panel and raised the issue about the commissions getting paid to agents by education providers. But interesting with the training and the social licence, there's a lot of companies that already meet that benchmark 1%. So if you were in effect asking or ensuring that employers were paying an additional cost on top of their commitment to training already, in effect, or for example, a business that employs a large number of overseas drillers, if they've got over 100 people on a 457 visa, their contribution is in the millions already, and you're asking him to pay up to $80,000 additional.
Yes, so there's one company, at least, where this was going to cost them $1 million a year that they're not paying now.
Yeah.
And because they meet the 1%, or they say they meet the 1%. So yeah, we that is controversial. That's why I said that it is a controversial approach. However, the amount of money is comparatively small, we thought. If it's $500 per worker, and you're paying that worker $100,000, it's a marginal cost. But we also thought it was important for the kind of integrity of the 457 system politically, that is that it is contributing, but contributing to the most disadvantaged Australians, but not to in those other areas. But there'll be a lot of pushback in the area that you're talking about. Exactly.
From the bottom end, I think it's fantastic because there's a lot of small businesses that have difficulties meeting the benchmark. So having a per user with that social licence, I think it's a great idea at the bottom end. Just the top end, you're right. I imagine there would be a bit of pushback.
Yeah.
The only other thing I'd say is I think the regional 457 program, the way it was operating under the Howard government, was fantastic, and a little bit disappointing to see that the only real discussions regarding regional areas was the use of a DAMA or a regional migration arrangement, or the labour agreement program, which is incredibly hard to use for a small business. So if you're a small business operating in Port Pirie and you need a crane driver, or you need one person to come in and operate, and they fall outside of the skill level 3 on the ANSCO, going through that labour agreement process, forget about it. It's an incredibly difficult and onerous task.
Yeah,
so I'm a little bit disappointed about
we
that.
recognise that issue, and in the report we do discuss it, and we are supportive of the case that you're making, and we've said that could be done through this process of if there's a ministerial advisory council, then regional people can put in their problem to that, and the group within the bureaucracy that's doing the analysis could say, okay, no crane drivers in Sydney, but crane drivers in regional areas is fine. That occupation could go on the list, but only
after the proper consultation.
But with a regional restriction. Yeah. So that is actually part of the report. No,
it's a good report.
Yeah. Okay. Thank you.
Good. Well, once again, thank you very much, Peter. And now we break for morning tea, and we'll reconvene at 11:20, please.